While they're serious, there's no penetration alleged here.
That's a 12-year-old. I don't even know how that came out of your mouth.
I'm sorry,
I,
Judge.
I'm, court's gonna speak.
This hearing opens with tension already in the room, and within seconds, you can feel exactly what kind of case this is going to be. A bond hearing is not about guilt or innocence. That comes later. Right now, the court is asking a different question. Is this person safe to release back into society while the case is ongoing? And that question becomes extremely complicated when the allegations involve a minor, a position of trust, and a long-term relationship between the accused and the alleged victim. We're dealing with a 44-year-old martial arts instructor, someone who didn't just interact with this child occasionally, but someone who was embedded in her daily life, her development, her environment for years. That's critical, because in cases involving grooming, the relationship itself becomes part of the alleged offense. It's not just about isolated actions, it's about influence, control, and access. And right away, you hear defense trying to frame this as a manageable situation. No criminal history, strong community ties, stable employment. These are classic arguments in bond reduction hearings, but on the other side, the prosecution is preparing to paint a very different picture, one that focuses on vulnerability, trust, and long-term exposure to a child. So here's the real question for this entire hearing. Is this a respected community member caught in a misunderstanding, or someone who used trust as a weapon? Because how the judge answers that question will determine everything that follows.
Judge, we are seeking to have the bond reduced in this matter. It's set at $150,000 cash or surety. It's not something that Mr. Wheeler is able to make. He is a 44-year-old resident of Washtenaw County, has lived his whole life. I say that initially because in the bond, I have the arraignment where his lawyer at the time said he has no family in the area, and the magistrate said that he may be a flight risk. I wanted just to correct the record on that because his family, the entire family except for his brother, lives in the state of Michigan, lives in the directly in the Metro Detroit area. His father is in the courtroom today. His brother, who came in from Maryland, is in the courtroom today as well. Mr. Wheeler was taken into custody in this case on October 15th, and he stayed in custody since that time. As I said, he has very strong ties to this community, and he is not a risk of flight whatsoever. He has no reported criminal history, Your Honor. He has a long and positive employment history. He's been employed as a martial arts instructor, and that's where the allegations arose from. But he's been employed there since 2010 when he was an instructor, and then he took ownership of the school in 2022. So for 15, give or take, years, he's been teaching at that location. This
is where the defense builds its strongest pillar: reputation. 15 years teaching children, running a business, building trust with families. On paper, this is exactly the kind of background that courts usually view favorably when considering bond reduction. No criminal history, long-term employment, deep roots in the community. These are all factors that typically argue against flight risk and in favor of release. But here's where things get complicated. In cases involving alleged abuse of minors, that same history can cut both ways. The longer someone has had access to children, the more the court has to consider whether that access itself created opportunity. What the defense calls community trust, the prosecution may frame as prolonged exposure. And notice how the defense emphasizes letters of support. Now, parents vouching for him. Even another attorney stepping in to say he trusted this man with his own child. That's powerful, but it doesn't directly address the allegation. It creates character context, not factual rebuttal. This is a classic courtroom dynamic, credibility versus accusation. One side is saying, look at who he's been for 15 years. The other side is about to say, look at what he allegedly did during those same 15 years.
Allegation that arose, he's been working with kids throughout that time. He has a lot of positive support. I've attached some letters of reference for Your Honor, and I can go through those, but I obviously don't need to. I've been getting more emails to my office. What can I do to help this individual? I was walking into court this afternoon. Attorney Jonathan Sachs said, Larry, come here. He brings me over. He says, Mr. Wheeler has been coaching or teaching my son for years. Do you need me to stay around? And I said, yes, as long as you can. But then he had to go. He said, please use my name to the court. This man has standing in this community is what I'm trying to tell the court. He's very close to his family. He's a caring son and brother. He's highly disciplined and respectful of others. His mother would be here. He cares for his mother in large part. She is aging and not well. She wanted to be here, but she's at Chelsea Hospital right now. She is sending her support from afar. As far as him being a danger to the community, Judge, he's not. Again, he's lived in this community his whole life. This is his first criminal charge lifetime. He's actively involved with his defense. He would do nothing to jeopardize it. And we're seeking to have Your Honor reduce this to a 10% in the lower amount that the family can make. There are conditions that can be placed upon him. We're asking Your Honor to modify that bond and I'll defer to the people at this time. As follows.
Your Honor, I wrote in my motion that I am asking that bond remain as set. I reviewed and charged this case and originally requested a $50,000 bond. And Magistrate Odetella, of his own volition, set the bond at $150,000 because he thought that that was appropriate. The victim in this case, the assaults and the grooming started when she was 12. She started training in martial arts when she was 6. Defendant was someone that...
This is the moment the tone of the entire hearing shifts. The prosecution introduces the word grooming, and legally, that's a loaded concept. Grooming isn't just about physical actions, it's about psychological conditioning over time. It suggests a pattern, a strategy, a gradual breakdown of boundaries. And notice how the timeline is presented. The child started training at 6 years old, but the alleged misconduct began at 12. That gap matters. It implies years of trust building before any alleged abuse began. In legal terms, that strengthens the prosecution's argument because it suggests opportunity, familiarity, and influence. Then come the specific allegations. Touching in private settings, isolated environments like a vehicle or studio. These details are not just descriptive, they're strategic. They aim to show control over circumstances, not random behavior. And here's where the judge starts thinking beyond just this case. In situations like this, courts often consider risk to the broader community. If these allegations are true, the concern isn't just what happened. It's what could happen again if access isn't restricted. So now the equation changes. This is no longer just about whether the defendant will show up to court. It's about whether releasing him creates a risk to other children. That's a much heavier burden for the defense to overcome.
She very much trusted and admired and looked up to, and allegations are that he took advantage of that and of a child. Began grooming her and assaulting her when she was 12. And then 3 days after the most recent incident, she reported it and told her mom what had been happening. He touched her breasts, her thighs, her vagina, and this was when they were alone together, either in his vehicle or at the martial arts studio. Also made several concerning statements to her, like that the age gap isn't that bad. I have concerns given that, yes, these are the first allegations, but his job is essentially direct access to children. I have concerns, obviously, given the report of this child, and I think that the bond is appropriately set at this time, especially given that the magistrate saw it, that it was even more serious than I requested, and increased it to $150,000 on his own. So I'm going to request that bond remain as it is set.
Briefly, Mr. Wheeler denies any of the sexual allegations that this young person is making. He has been working with children and adults for 15 years. He had been working with this individual for 8.5 years. And in her own statement, she says that there was some touching that happened and then she continued to stay for the next 20 months.
This is a risky argument from the defense, and the judge immediately pushes back on it. The implication here is subtle but significant. If the alleged victim continued to attend the dojo, then maybe the situation wasn't as coercive or harmful as claimed. But in cases involving minors, that logic doesn't hold up well in court. A child's behavior cannot be interpreted the same way as an adult's. The judge steps in quickly to clarify that point. Because legally and psychologically, a child may remain in an environment for many reasons: fear, confusion, emotional attachment, or simply lack of control over their own circumstances. And this is where the concept of power imbalance becomes critical. A 12-year-old is not making independent decisions in the same way an adult would. They rely on parents, routines, and trusted figures. If that trusted figure is the one being accused, the situation becomes even more complex. The judge is essentially saying, you can't use a child's continued presence as evidence against them. That's not how the law interprets these dynamics. This moment is important because it shows the court rejecting a narrative that could shift blame, even subtly, onto the victim. And once that argument is shut down, the defense loses a key angle. From here on, the focus moves back to risk, responsibility, and credibility.
There's a lot of facts.
Yeah, but I don't know what you're asking me to make out of that, Mr. Margolis.
Only that there's one person who's alleging this, and that one person continued to stay at the dojo.
Yeah, but this isn't a circumstance. Well, it's a child that then she's not in a position to remove herself, right?
Well, I mean, it's rose up and became a coach, and she was very involved. That's all I'm saying.
No, what I'm saying is you're making it sound as though this is an individual who this is going on, or is at least alleging that this is going on, and chose to stay. I mean, she's a child, so the reality is she's going to be there until such time as she has the fortitude to tell her parents, because they're the ones that are going to take her out, right? I mean, or are you saying something different?
No, I'm not gonna quabble, or is that the word? I don't think it's important to contest that point with the court. How's that?
Yeah, but I'm trying to figure out what's your statement, how I'm supposed to take your statement that this is occurring to her and that she stayed. What am I supposed to do with that notion that she stayed? Because when she stays, it's my presumption, unless you know something different, is that she stays because she can't or doesn't tell her parents, so then she's not taken out.
I didn't get that impression from my review of her statement and the discovery, Judge. I got the impression that she stayed because she said it was her whole life. The dojo and the dojo community was her whole life, I think, is what I recall the statement being that I reviewed this afternoon.
Okay.
The point is that I'm trying to make is that there's a PPO in place. She stopped going. There was no problems with him, with Mr. Wheeler, trying to get her to come back or going to the house or anything like that. He is a respectful person. He's a good person, Judge, and he denies this. And so all I'm asking is for his presumption of innocence to be, upheld. Allow him to get the benefit of the doubt without there's no evidence other than her statement, which is common in these cases, as Your Honor well knows. Again, he's been in this community, contributing to this community. That's why I attached, for Your Honor, all the reports, the Quest references. Quest has changed my life. An amazing experience. Our kids love spending time at Quest. So we have a community of children that have had great experiences. And yes, we've had this one that is now making these allegations, but probable cause. He's never been in trouble in his life. He's college educated. His family's here in support. He has a close family. I'm just asking for him to be given a reasonable bond such that we can work together on the outside.
What would he, presuming he were released, is he going to continue to operate this business or what?
So he doesn't have to, if the court were to release him, there are conditions. He should not, if there are court such as like, okay, let's not allow him to be around kids unsupervised. That's an easy one. There's been no,
Well, but that's not an easy one because,
as a condition.
as I read, because I pulled the swear
Mm-hmm.
And the other thing, and then as I'm reading this, I mean, there's an indication that somehow or another he's of this child. Why is that occurring? I mean, I get
No, it's a great
a
question.
teacher.
Yep. So the family only had one car. He was close with mom and the family too. So the family would rely on him for transportation for a long period of time.
Now, this detail changes everything again. Transportation. The fact that the family relied on the defendant to drive the child creates a new layer of access and trust. This isn't just a teacher-student relationship anymore. This is someone integrated into the family's daily logistics. From a legal standpoint, this strengthens the prosecution's argument significantly. Why? Because it shows increased opportunity for isolation. Private car rides, one-on-one time, situations where supervision is minimal. These are exactly the conditions courts look at when evaluating risk in these types of cases. But it also raises a deeper question. How did this level of trust develop? Because for a parent to allow someone else to transport their child regularly, there has to be a high degree of confidence in that person. And that's what makes allegations like this so disturbing when they arise, because they challenge not just actions, but trust itself. At this point, the judge is no longer just evaluating facts. He's evaluating systems, how this relationship functioned, how access was granted, and whether that structure could still exist if the defendant were released. And that brings the hearing closer to its core issue, not just what happened, but what could happen next.
This was a family that had been at the dojo, and these are small, tight-knit communities. And so this was a family that was at the dojo for 8.5 years. And so they had one car. And so mom would request that he assist in the transportation. And he would. That's why, to answer the court's question.
So the other part of that, though, is that, so if I were to release him, or he were released, he would go back into the same environment to work?
Not necessarily. I think the lease has now been gone. He has other abilities. He also has another job doing something else. I forget exactly what it was. What was the other job? Yeah, he also was working at a warehouse doing shipping and receiving to make extra money. Yes, that was his business. He eventually in his life.
Okay, I'm not getting a straight answer. If he were released, would he go back to operating this business?
No.
This is the turning point of the entire hearing. Up until now, both sides have been arguing around character, allegations, and background, but the judge cuts straight to the operational risk. Access. Not past behavior, not reputation. Access. Because in bond hearings, especially in cases involving minors, the court's priority is prevention. The judge is not trying to solve the case right now. He's trying to prevent a worst-case scenario from happening again while the case is pending. And notice how direct the question is. Will he go back to the business? That's not a casual inquiry. That's the judge identifying the exact environment where the alleged conduct took place. If that environment still exists and the defendant can return to it, then the risk hasn't been removed. The defense tries to navigate around it, suggesting conditions on alternative employment. But the judge isn't satisfied with vague assurances. He wants certainty. He wants a clean, enforceable answer. And here's the problem. The defense doesn't give one immediately. Instead, the answer shifts, evolves, and becomes inconsistent. And in a courtroom, inconsistency is dangerous, not just for credibility, but for decision-making. Because if the judge cannot clearly understand what will happen if the defendant is released, then the safest decision is to assume the risk remains. And that's exactly where this is heading.
But it's an ongoing concern, right?
Again, I have to look at the man's history. I have to look at his family support. I look at his ties to the community.
Mr. Margolis, I get all that. What I'm trying to figure out is the allegation. I have to balance the protection of the public and the safety of the public, as well as this defendant's risk of flight and other factors. And so I'm asking these questions about what is he going to do? One thing that I would be certainly is always the case with these types of cases is access to children. And so I asked the question, is he going to operate this business? And I'm not getting a straight answer.
The answer is no. The answer is no.
But So what happens to this business? I mean,
It no longer is going to be operating, Judge. The lease, I believe he's already been a problem with that.
with what?
I think they either terminated his lease or he's out, correct? No longer operating. Is that correct? Correct. It's not even operating anymore.
When did that stop?
Probably when he got arrested.
May I just briefly respond to?
Yeah, I just want clarification. The business stopped when he got arrested.
Now the defense attempts to stabilize the narrative. The business stopped when he was arrested. On the surface, that sounds reassuring. It suggests that the risk environment is no longer active. But the judge immediately starts dissecting that claim, and this is where precision matters, because stopped is not the same as closed. A business can be inactive temporarily and still exist structurally, and if it exists, it can restart. That distinction is critical in legal reasoning. The court isn't just asking what is happening right now, it's asking what could happen if the defendant walks out of custody tomorrow. And as the questioning continues, cracks begin to show. The lease isn't terminated, the business still technically exists. The shutdown appears reactive, not permanent. From the judge's perspective, that creates uncertainty. And an uncertainty in risk assessment is unacceptable, especially in cases involving potential harm to minors. This is where the defense loses control of the narrative. Instead of presenting a clear, controlled situation, they're now reacting to the judge's concerns in real time. And once the court senses that lack of clarity, it starts leaning toward caution.
So it's not something else that stopped the business. This stopped the business.
That's correct.
So it continued through October? When?
August.
August? Well,
Well, the business.
Yeah, that was in October, Judge. This was reported in August.
I know, I get that part, but I'm just saying, I'm trying to figure this out. If he had told me I closed the business last year for X reasons, how do I know that this business has ceased?
So these allegations blindsided him. And the arrest obviously was shocking. And so the business is just pretty much folded. And again, much to the dismay of a lot of parents who sent me letters saying he's been working with my kids for years. We have great respect for him.
Fine, but that doesn't, this really doesn't answer the question about the business stopping. Because basically there's still a business. It's just not running because he's here with us. And that's probably a more appropriate way to look at it, isn't it?
Yes, sir.
So is his lease terminated? I would find it hard to believe that a lease doing the business, I find it hard to believe that if this occurs in October, that a lease terminates to that extent.
His brother has been working with the lessor. He's been in touch with the property manager. He's asked for some grace because they don't know what was going to happen. But my client indicates that he has no intent to go back and operate that business.
Well, see, now that's a whole different scenario. Because what you were telling me is that the business isn't operating, that the lease had been terminated, and that the business isn't there. The reality, as I'm hearing it now, is the business is there. It is, for all practical purposes, it is a functioning and ongoing concern that may not be doing anything at this very time.
I totally agree with that. Because he is the business. Without him there, it can't operate. But because of the court's concern, we don't need to be in that business or operating that business.
But Mr. Margulis, you can't tell me that his lease hasn't been terminated.
That was my fault. I thought that it was terminated, Judge. I must have, thought that when a conversation with my client. That's not something that he is saying either. So that's me. I don't know what respectfully that has to do with his bond.
Well, it has everything to do with his bond, Mr. Margolis, because that's the concern that the court has.
This is the judge drawing a hard line, and it's a critical moment. The defense tries to separate the business from the bond decision, but the judge shuts that down immediately. Because in the court's eyes, the business is not a side issue, it's the central issue. It's the alleged location of the misconduct. It's the source of access to children. It's the environment that must be controlled if the defendant is released. And the judge makes it explicit. Bond decisions are not just about flight risk. They are about public safety. That includes preventing potential future harm, not just responding to past allegations. This is where many viewers misunderstand the legal system. Bond is not a reward for good character. It's a calculated risk assessment. And right now, the judge is signaling that the risk hasn't been neutralized. And the defense suggests conditions. Don't go to the business, avoid children, but the judge is thinking deeper than that. Enforcement becomes the issue. How do you guarantee compliance? How do you monitor behavior? How do you ensure that no indirect access exists? These are not simple questions, and the more complex they become, the less likely release becomes. At this point, the judge is no longer persuaded by general assurances. He wants structural certainty, and he's not getting it.
The court, he has access, just on the allegations, he has access to this child through that business. You're asking me to let him out where there are other children. And so naturally, I would want to know, is this business going to continue? That's what it has to do with his bond. And in fact, I have great concerns and can't see that of whether or not I should release this defendant.
I understand, Judge. I guess I was looking at it a little bit differently. When she reported this, she stopped going. And I know you're concerned about other potential allegations coming out, but I wasn't looking at it that way because I'm only hearing the positives from parents saying we loved with my kids, reaching out as a parent of two of the younger students, R and M, tremendous respect. So, he has a lot of goodwill with other people in this community who have children. In a perfect world, he'd be able to continue, and the complainant in this case, would be not going back because she's not. But we are willing. I mean, he understands the court's concern, and that's why he is willing to not operate the business. The lease is not terminated, but there can easily be a condition that he can't go to that business. Yeah.
Ms. Willie.
I think I just have 3 points. Mr. Margolis sent as part of his motion, and also I reviewed, and he stated on the record that he has a lot of community support of people saying they send their kids, but do these people know why he's not there, is my question. Second, when viewing the website of Quest Martial Arts, there's still an option to sign up now for spaces in November. So it still seems to be operating, still seems to be allowing people to sign up. Third, I take issue with the suggestion that we're placing blame on the child for continuing to return and spend time with the defendant as if that is her fault.
This is one of the most emotionally charged moments in the hearing, and it's strategically powerful from the prosecution. The prosecutor directly confronts the implication that the victim bears any responsibility for staying in the environment. And this is not just emotional, it's legally significant. Courts are extremely sensitive to narratives that shift responsibility onto minors in abuse cases. What the prosecutor does here is reframe the entire situation. Instead of asking why the child stayed, she explains why leaving would have been difficult. The dojo wasn't just a place, it was her social world, her identity, her routine since childhood. And that reframing matters, because it turns what the defense tried to use as doubt into an explanation of vulnerability. Then comes another key point: reporting. The child reported the incident within days of the most recent event. That strengthens credibility in the court's eyes. It suggests immediacy, not fabrication over time. The prosecutor is building a narrative of trust, disruption, and courage. And in doing so, she reinforces the argument that this is not just an isolated allegation, it's a situation with emotional and psychological depth. At this stage, the defense is no longer just arguing against facts. They're arguing against a narrative that the court is starting to accept. And once that narrative takes hold, the balance begins to shift decisively.
She was a huge part of this community, very clearly. She started there when she was 6 years old. And so what it took for her to tell someone what happened to her was probably very challenging because she had the understanding that, yeah, this was going to end for her. This community that she had was no longer going to be available to her because she couldn't be around him anymore and she couldn't deal with this anymore. I think she blew up her own life too and doesn't have that community anymore. So I take a lot of issue with that. It's somehow a child's fault for returning to a trusted figure when he was grooming and abusing her. I think given all of this information, I just think a bond is appropriate. And I would ask you to rule in that way.
Anything else, Mr. Reynolds? Because I'll be honest with you, I don't like the fact that I didn't get a straight answer about this business. Because this business is, in a lot of ways, when you just analyze it on its face, the epicenter of this. Because without this business, there isn't access to this child and potentially access to other children. So one of the concerns that the court is going to have is the protection and safety of the public. And one thing that the court would have to take very seriously is cutting as best it could, if I were to release the defendant, is cutting that access. And I'm not getting a straight answer about this business. You're telling me initially that it ceased because the landlord said this, then it just was.
I get that,
Excuse
Judge.
my French. It was just a very squirrely answer to what this is and whether or not it exists. And I'm not even sure, at least at this point, I probably haven't gotten to that point yet, but if he were released, how would I fashion any language that he can't do this? Because apparently it's still going, the business is still going. There's still.
This is the judge openly admitting something you rarely hear stated this clearly. He doesn't know how to safely release the defendant under these conditions, and that's crucial. Because when a judge cannot confidently design conditions to mitigate risk, the default decision is to deny release. Notice the language. How would I fashion any language? That's not frustration for the sake of it. That's the judge thinking through enforceability. Conditions like don't contact minors or don't return to the business sound simple, but in practice, they can be difficult to monitor. Especially when the business still exists, the website is active and communication channels remain open. The defense suggests solutions, home confinement, restrictions, but the judge is looking at the bigger picture. Why, if the system around the defendant hasn't been fully shut down, then conditions become harder to enforce. This is where the hearing shifts from debate to conclusion. The judge is no longer weighing arguments equally. He's identifying unresolved risks, and once those risks remain unresolved, the outcome becomes increasingly predictable.
There still is the option for students to take classes in November.
That's on me. I didn't look into that with him. I just was making assumptions, Your Honor. There are easy ways. A home confinement is one way. Don't go to Quest is another way. Again, there's a PPO in place. She is not gone for many months. I'm sorry about not understanding that we still have the website up, but that's easily taken down, Judge. He denies these allegations. He still is presumed innocent. He has no criminal history.
I'm not taking away his presumption,
Understood.
Mr. Margolis. I am just looking at, let's be real about it. Typically, when you have these types of circumstances, regrettably, and I'm not saying that's the case here, but regrettably, it's usually not just one. You all of a sudden get others that come out. And so from the best I can understand, this is a business that's operating, and in a lot of ways, based upon the information that you supplied to the court, there are these children that are involved with this business and taking classes there and that kind of thing. And so naturally, one of my first questions are going to be is there still this place where these children are going to congregate and be part of this? And I don't get a straight answer. I don't. And the only conclusion that I can come to right now is this is still an ongoing concern.
This is where credibility begins to collapse in real time. The judge is no longer just questioning facts. He's questioning the reliability of the answers being given. And in a courtroom, once credibility starts slipping, everything else follows. Notice the repetition. I don't get a straight answer. That's not accidental. The judge is signaling that the issue is no longer just about the business. It's about trust in the information being presented. From a legal standpoint, this is devastating for the defense, because bond decisions rely heavily on the court's confidence in what it's being told. If the judge cannot rely on the defense's representation of the situation, then any proposed conditions become meaningless. And the business remains the central problem. It still exists. It still has potential access points. And it still connects the defendant to children. Here's the key takeaway. The judge isn't saying the defendant is guilty. He's saying the situation is unclear, and unclear situations with potential risk lead to conservative decisions. This moment effectively locks the direction of the ruling, because once the court loses confidence and clarity, it defaults to caution. And caution, in this context, means keeping the bond exactly where it is.
And then the question is how do I keep him out of that? How do I keep him from doing, if I were to release him, how do I keep him from doing all of that?
They're all canceled.
They're all what?
The business is not, he is the business. There's no other quest without him. Yes, we haven't been booted out of the place yet, Your Honor, but everything is canceled. The lease is not yet terminated. That's correct. That was me making assumptions that I should not have made.
The business as a business concern is still operational.
It is not. And I know that's not the answer that, and you're shaking your head, but again.
I'm shaking my head because I'm trying to figure out how you get to that. Is the business in existence?
Yes, it still is in existence. Yes, but it's not operational and all the classes are canceled. That's all I'm saying.
And how do I know all of the classes are canceled?
That's the proffer we're making. You can put him under oath and ask him if you like.
Well, if he's not telling his attorney and correcting his attorney, why do I think he's going to tell me the truth?
I don't think I asked specifically the questions that Your Honor would like me to ask.
If you're saying something and it's not true, he can stop you at any moment and say, no, that's not it. And how do I know they're canceled? What was the process by which all of these things have been canceled?
His brother was in the courtroom. Mr. Wheeler had his brother send a message to everybody canceling all classes.
Now the defense brings in a new element, a live witness, the defendant's brother, to restore credibility and provide clarity about the business operations. This is a strategic move. When verbal explanations start to fall apart, bringing in someone with direct involvement can help rebuild trust. And the brother does provide more concrete details. Emails sent, classes canceled, payments stopped. On paper, that sounds like progress. But listen carefully. The judge is not just interested in actions taken. He's interested in documentation and verification. Was there an email? Can it be produced? Who received it? What exactly did it say? Because in legal proceedings, claims are not enough. They need to be supported by evidence. And there's another subtle issue here: timing. These actions appear to have been taken after the arrest, not before. That suggests the shutdown was reactive, not proactive. From the judge's perspective, that doesn't eliminate risk. It suggests that without intervention, the system would have continued operating. So while the brother's testimony adds detail, it doesn't fully resolve the core concern, control over the environment. And until that concern is resolved, the court remains cautious.
Because he's been in here, he has not been able to shut down the website. That is what I'm being advised.
Do I have a copy of that email? Has that been provided to the people?
His brother can be questioned as well. He's in the courtroom. Is that correct, sir?
Pardon?
Stand up, please.
I've been working with,
Why don't you come up here and introduce yourself to the court? What's your name, sir?
my name is Adam Wheeler. I've been working with Matt to the degree possible while he's incarcerated to at least do some triaging to the business, understanding that operations cannot continue if Matt is incarcerated. So I've worked with former leadership to issue a notice to current enrolled students that classes have been canceled until further notice. My father, who's in the courtroom, has helped me to put signs on the doors to say that class is closed till further notice. And I also worked with the former leadership to put a stop payment on all tuition.
So, was there an email sent to all students regarding that?
Yes,
Is there a copy of the email?
I can provide it to Larry as soon as I get out of here.
Give me right now.
I don't have my phone on me.
Oh.
I didn't think that was allowed.
How many students are there?
Between 40 to 50. Does that include adults as well? That includes adults as well.
Have the parents been notified as to why he's not there?
I can speak to that to a degree. In the email that notified the currently enrolled students or parents of the closure, the former leadership and I included our contact information for questions and concerns. So I have spoken openly with some of them, and I'm happy to confirm more of that.
Well, what was said in the email?
That due to unforeseen, I believe, I'm paraphrasing, due to unforeseen circumstances, classes at Quest are closed until further notice. It was very short, and then there was a second email to notify them of the stop payments to the tuition, and then the inclusion of my contact information to reach out with any concerns.
But if I'm a parent and I'm sending my child there, then all I know at this moment is that things have stopped, but I'm not informed as to why.
This is a critical ethical and legal question. Transparency. The judge is now focusing on what the parents know, or more importantly, what they don't know. Because if a business involving children shuts down suddenly and parents are not informed of the reason, that creates a gap in awareness. And in cases like this, awareness is directly tied to safety. The brother admits that the emails were vague, unforeseen circumstances. No mention of charges, no explanation of allegations. From a legal standpoint, that raises concerns, not because there's a legal obligation to disclose everything, but because it affects risk assessment. If parents don't know why the business closed, they cannot make informed decisions about their children's safety. And if the business were to reopen, or if communication resumed, that lack of transparency could become a problem. The judge is essentially asking, if this situation is serious enough to warrant criminal charges, why hasn't that seriousness been communicated to those directly affected? And that question doesn't get a strong answer, which again reinforces the same pattern. Incomplete information, inconsistent responses, and unresolved risk. At this point, the court is seeing not just a case, but a system that hasn't been fully secured.
Is that what I'm hearing?
To a large degree, there has not been a communication to the entirety of the enrolled students or parents. As I said, some parents have reached out, or I've reached out for character letters, and that has warranted transparent conversations as to why the closure is happening.
And there was that letter, sorry to cut you off, sir. There was the letter from that one person that I had sent on. It was the last one that I had sent. I think it was either a couple of days ago where someone said he's aware of these and he can't speak. He was very circumspect with what he was saying. I can only talk about his relationship with my family, and it's been amazing. I'm being clear that I don't know everything about everything, but I think it's a small community. Would surmise that a lot of folks are aware of this. I do know that the complaint.
Okay, certainly one can make all kinds of assumptions, but I don't know, why weren't the parents told?
That may be a better question for the other side of the aisle here. I do know in her statement.
What do you mean? Why would that be their question?
Well, I mean, surely Your Honor is not upset with me for not issuing a.
I'm not upset with anybody. I'm just asking a question.
I think some of them were. I know that the complainant and her mother, at least the complainant, the minor, talked with her dojo brother and let him know. I know that she talked with another, according to her statement, she talked to somebody else at the dojo and let him know. So I'd be hard pressed to believe that a lot don't already know, given the closeness of this organization.
So I go back to my point. You're sending an email out. Why aren't the parents informed?
That he's been charged with these offenses?
Yeah, I mean, he can say that he hasn't been convicted of anything. He can deny absolutely he can say, but they can say whatever they want to say. I'm just trying to figure out why haven't they been informed that this is occurring?
This moment intensifies the pressure on the defense. The judge is now pushing beyond operational details and into responsibility. Because this isn't just about whether the business is open or closed, it's about how the situation has been handled. And from the court's perspective, the handling appears fragmented. Some parents may know, others may not. Communication has been partial, indirect, and inconsistent. And that creates a dangerous scenario. Uneven awareness in a community involving children. The defense attempts to pivot, suggesting that disclosure could be made a condition of bond, but that misses the judge's point. The concern isn't future action, it's current reality. Right now, the system is unclear. Right now, the communication is incomplete. Right now, the risk is not fully controlled. And in bond hearings, the court doesn't operate on future promises. It operates on present conditions. This is where the defense runs into a wall, because they're offering solutions for tomorrow while the judge is evaluating risks today, and that mismatch is critical.
If Your Honor wants to make that a condition of bond, I
I'm
think,
not,
yeah.
I want to know
Embarrassing.
why, so you're asking me, Mr. Margolis, to let this individual out under circumstances where it's almost a higher level of trust and the authority involved is at a higher level in this type of environment. In a martial arts environment, but it is sensei, but you've got a higher level, and you're asking me to release this individual back into a circumstance that it potentially could occur. And I'm trying to figure out, well, when this happens, what's been done with this business? Do these parents know these other individuals?
I venture to say some do and some may not. But they've probably been asking a lot of questions why they can't go anymore and why they can't go. I think for my people, for my guy, it was such a shock. This is like a very unusual situation in his life. He didn't know what to do. The brother, I can't fault the brother for not letting everybody know. But maybe that's something that we can do.
Look, I'm not faulting anybody. I'm trying to, in setting bonds, I'm trying to make a risk assessment. That's really what I'm trying to do. And part of the only way that you can make a risk assessment is to look after this. I imagine it was a shock as to what has transpired then. That's one way of going about doing it. I worry about a setting that, and I don't really want to call it a school, but a trusted setting where this allegation has been made, at least to the extent of reasonable suspicion and probable cause, charges have been brought, and this thing doesn't do anything to inform everybody else that may or may not be at risk. I don't know. One can say, yeah, well, we let certain people know and we did this, and I guess that's one way of looking at it, but I mean, there would also be, and I'm not sure which way one would head, there could be a darker reason in looking at it that will let some people know, but those that may come out and say something else, we won't let them know.
This is one of the most serious implications raised in the entire hearing. The judge introduces a possibility, not an accusation, but a possibility, that selective communication could be intentional. He's not saying that's what happened, but he's acknowledging that the lack of full transparency opens the door to that interpretation. And in legal reasoning, perception matters. If a situation can reasonably be interpreted as risky or incomplete, the court must account for that possibility. This is where the judge's role becomes very clear. He is not here to assume best intentions. He is here to evaluate worst-case scenarios. And the worst-case scenario here is not just past misconduct, it's ongoing risk through incomplete communication and continued access points. The defense tries to explain the situation as confusion, shock, the lack of preparation, and that may very well be true. But from the court's perspective, intention does not eliminate risk. And that distinction is everything, because even if every inconsistency is innocent, the outcome is the same. The system is not secure. And an unsecured system in a case involving minors is unacceptable for release.
So we target our information. And I'm not saying that's what was done. I'm just saying there's a lot of ways one can look at this. And where would the defendant, if the defendant were released, where would he be residing?
Manchester. His mother has a home in Tecumseh.
Does the defendant have a different address than he did before? Because I saw something on.
That was his former address, Your Honor, Lake Village Drive, apartment 201.
I know. But then my understanding was going to be another place. And now I'm being told that he would be residing with his mother.
So he has a new girlfriend, and his intent at all this, he was planning on moving in with his girlfriend. That's off the table now, not necessarily because of the girlfriend, but because I think she has children, and we don't want to pressure any, we don't want to make the court or magistrate, we don't want to make the magistrate concerned about that. His family is here, they're loving and supportive. Mom, he's lived there before, probably. And mom has a house that is suitable.
Tell me, if he's out, what stops him from operating this business?
This is the most direct risk question of the entire hearing, and the defense does not have a solid answer. The judge strips everything down to a single point: control. Not intention, not promises, not character. Control. Because intentions can change, promises can be broken, but structural control, actual barriers that prevent behavior, that's what the court relies on. And right now, the judge is identifying that there is nothing physically or legally stopping the defendant from resuming operations if released. The business exists, the infrastructure exists, the connections to students still exist. The defense says he'll close it down. But that's a future action, not a current reality. And that distinction matters more than anything else in this moment. The judge is essentially asking, if I release him today, what guarantees do I have that tomorrow this environment doesn't reopen? And the answer is none. That's the turning lock on this decision. Because without enforceable guarantees, the court cannot justify taking that risk. At this point, the outcome is no longer uncertain. It's forming.
He has other opportunities for employment.
What stops this business from operating?
He's closed it down. He's not, or he.
It's not closed down. That's the problem. The problem is, I asked the question, what stops him from operating the business? There is nothing. In fact, there is nothing that stops contact to the individuals that haven't been contacted to say to come back to the.
He'll close it down, Judge. It has to be closed down. That's what stops him.
I'll be honest with you, I don't want to be, well, I'm in the position of sometimes having to second guess things. But I am troubled by the responses that I'm getting to my question, particularly as it regards this business, which by its nature attracts young people. And when I ask about that business, when I ask what's it, I'm not getting for the court's perspective, a satisfactory answer. That's done.
Well, please don't hold that against my client. That's me.
Well, I'm not holding.
Well, I mean, I understand.
Holding it against anybody. I'm saying I'm not getting a satisfactory answer. It is what it is. This business is not closed down. It still exists. It's still there.
But he won't go there. That's easy enough to fashion as a condition. That's why I keep going back to that point. He won't go there.
Then why are people still encouraged on the website to sign up?
It's an oversight, Judge. This took the whole family by shock. They're freaking out. They don't know what to do.
The defense now shifts to explanation: shock, confusion, oversight. And to be fair, in real life, situations like this can unfold chaotically. Families don't always respond perfectly under pressure, but the courtroom doesn't operate on emotional context. It operates on risk evaluation. And from the judge's perspective, oversight is not reassuring. In fact, it raises another concern. If something this critical was overlooked, what else might be overlooked? Because the issue here isn't just the website still being active, it's what that represents: an open door, a signal that the system hasn't been fully shut down. The defense is essentially saying, we didn't think about it. But the judge's response is clear: you should have. Because in cases involving children, access control is not optional, it's fundamental. This moment reinforces the same pattern we've seen throughout the hearing: reactive responses instead of proactive control. And that pattern continues to push the court toward caution. At this stage, the defense is no longer strengthening its position. It's trying to recover from damage.
I should have thought of this and told them, this is what we need to do. Frankly, I didn't think about that. I didn't think about that. That was what was going to be most concerning to the court. But it's easy enough to fashion a restriction
Well,
or
Mr.
on
Margolis, I
house
don't know how
arrest.
you can't not think that. That for any court, and I'm sure it was a factor for the magistrate, and usually is, which is why he can't go to that other address. It's anything that could put him in contact with kids. That is basic and simple to anything set in terms of setting a bond on these cases. It is that basic.
And I believe that was part of the magistrate's order, is that he can't go to that address. I believe, but it's easy enough to put that as a condition. Again, these are allegations. While they're serious, this court and I have seen more serious type. There's no penetration alleged here. Not to lighten.
Mr. Margolis, I don't think you even want to say that.
Correct.
That's a 12-year-old, 14-year-old girl who has alleged to have, I don't even know how that came out of your mouth.
I'm sorry.
This is the most emotionally charged reaction from the judge in the entire hearing, and it matters. The defense attempts to minimize the severity of the allegations by pointing out that there was no penetration, and while that may be legally relevant in certain contexts, in this moment, it backfires. Because the judge immediately reframes the situation, this involves a 12-year-old child, and that changes everything. The court is not evaluating degrees of severity within adult standards. It's evaluating conduct involving a minor, and in that context, any inappropriate contact is taken extremely seriously. The judge's reaction here is not just emotional, it's corrective. He's shutting down any attempt to downplay the allegations, and this moment likely seals any remaining doubt in the court's mind. Because if the defense appears to minimize the seriousness of the situation, it further erodes confidence in their overall argument. At this point, the tone is set, the court is not persuaded, and the defense has lost the ability to redirect the narrative. This is the final blow before the ruling.
Court recalls the case of the people say Michigan versus Matthew Wheeler,
Larry Margolis on behalf of Mr. Wheeler.
and he's here. Anything else from either side for the court rules?
Nothing additional from the people here.
Briefly, Judge, he is Quest. Quest is no longer going to be operating. He has a lot of support in the community. This is a good man who has done a lot for this community. He is denying the allegations. He has a place in Tecumseh to stay if he were to be released. We're asking for a reasonable bond that the family can make.
Given all of the circumstances in the case, and the court's primary concerns are whether or not the defendant is a risk of flight and the danger to the community. In these cases, danger to community can sometimes be viewed as a very tricky thing, but a lot of it has to do with the access to children, which was the focus of the court's questions. As I made it clear as the argument was going forth, I wasn't satisfied with some of the answers, some of the actions that have been taken since the point of the defendant's arrest and incarceration and arraignment on these charges, which almost lead the court to believe that this concern will continue. I do not know, but there is continued this access to enrollment. I understand what the brother is indicating that they've done, but I also I hear what was said and then what turns out not to be the case. And so at this juncture, based upon what I'm hearing, the motion to reduce bond or modify bond will be denied. Bond will continue.
And here it is, the decision. The judge denies the motion to reduce bond, and the reasoning is clear when you look back at the entire hearing. This was never just about the defendant's background. It was about unresolved risk. The court explicitly mentions two factors: danger to the community, access to children. And throughout the hearing, both of those concerns remained active. The business still existed. The communication was incomplete. The answers were inconsistent. Even though the defense presented strong character arguments, they failed to eliminate the structural risks. And that's the key takeaway. Bond decisions are not about proving innocence. They're about managing uncertainty. The judge even leaves the door open for future reconsideration. That's important. It means the decision is not permanent. It's conditional on change. If the defense can later demonstrate that the risks have been fully addressed, business shut down, access eliminated, conditions clearly defined, they may have another chance. But today, in this moment, the court did not see enough control to justify release, and so the bond stands.
In saying that, if circumstances change that can alleviate some of the court's concerns, I have no problem entertaining a motion again. But in terms of what I'm hearing at this point, I'm going to continue as bond and deny the request. All right. This is also set for PCC at this time. So what are we going to do with that?
I think we have all the discovery in. Is that correct?
As far as I am aware, yes.
Detective, or do you anticipate anything additional?
Not at this time, sir.
Okay. We can, since he's in custody, Judge, I'd ask it be set for an exam date.
How soon do you want it?
What's the next available?
Kind of jammed up there, but the 25th.
Is that Thanksgiving week?
That is the week of Thanksgiving.
Yeah,
Tuesday.
I'm going to be out of town. The week after that or the week before would be my preference.
Either is fine with people.
And Your Honor, I heard Your Honor's ruling loud and clear, and we anticipate addressing that immediately.
Oh, which date do you guys want?
If we can set it for the 18th, and then that's too busy for you.
Well, I'm not going to set it on the 18th. If I will set it for the 18th if that's what you want me to do, but I don't know how many witnesses you anticipate having.
The 18th is fine. It just needs to we need a date certain because the victim's obviously gonna have to miss school.
See what?
She's gonna have to miss school, so I just don't want her to comment for.
Is it Ann Arbor Public Schools, do you know, or at least
Community.
Washington Intermediate School District, because I can go with that. Hang on, just do that. So the problem's going to be, that means that if I try to accommodate that, you're not available, that I'm going to get closer to the break time for school, or I will give a special time later in a day to conduct it. It'll be a sooner date, but later in the day, so that.
The 18th is fine.
That's fine.
Okay.
Understanding that she would then, I'm going to set it at 9, and that's going to be a whole day.
Yeah.
Is that what you want to do, folks?
Yes.
All right. Because then one of these will clear. Got it. Okay. So here's what I'll do. I'm just trying to meet both needs. You want it as soon as possible, obviously. You got a victim that there's a school issue. So I will set the 18th, but I'm going to set it later in the afternoon. And that way I can accomplish both, I think, in that regard. Okay.
Thank you, Judge.
So I'll set preliminary examination in person on November 18th, 2025 I'm going to set it at 2 because I want to make sure we have enough time, because I think people in the evening have childcare issues that they have to deal with. So I want to make sure that there's not a problem there. So I'm going to set it at 2 p.m. on the 18th. I would like to say that I'll be in this courtroom, but I may not. It may be that I'll have to shift around to a courtroom, and that'll be before me.
Okay.
Get it in and get it heard.
This hearing ultimately comes down to a single principle: risk versus assurance. On one side, the defense presented a man with no criminal history, strong community support, and years of positive involvement with children. On the other side, the prosecution presented serious allegations involving a minor, supported by a timeline, specific claims, and concerns about grooming and access. But the deciding factor wasn't just the allegations, it was the uncertainty surrounding the environment in which they allegedly occurred. The business remained active in some form. Communication with parents was incomplete. The defense struggled to provide consistent, verifiable answers about control measures, and for the court, that uncertainty outweighed everything else. Judge Simpson made it clear: without clear safeguards, without full transparency, and without eliminating access to potential risk environments, releasing the defendant would be premature, so the bond remains at $150,000. But this case is far from over. The preliminary examination is set, and that's where evidence will begin to take center stage. That's where the narrative shifts from risk assessment to factual determination. Until then, the legal system holds its position, cautious, deliberate, and focused on protection. If you found this case as intense and complex as it unfolded here, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more in-depth courtroom breakdowns.